folks, we're going to bring in our guest in a second. I do want to show you, though, that we've stopped our verdict clock in the Washington versus Ali and Ali case because the jury has gone home for the day in that attempted honor-killing trial of Ihsan and Zahra Ali. Deliberations are going to resume tomorrow. They deliberated now over 2 days, 13 hours and 42 minutes. It's a tough case, and it's showing in the deliberations. Of course, we'll keep you updated on that case as soon as a verdict is reached or any other questions from the jury. Let me bring in my guest now here to discuss playing out in Montana is National Trial Attorney Michael Jaafar. Michael, great to see you. Thank you so much for joining me here on the program. I want to get your initial thoughts on this case. It's a self-defense case. We saw, or the jury saw, some body cam video, very cooperative defendant. He's already beginning to defend himself. He defends himself a little bit on the phone when he calls 911, talks about the guy tried to attack him, had to shoot him, telling the cop, look, he tried to attack me, shoot him. But he's very compliant, doesn't seem to leave, and the defense attorney on cross makes a point of that. What do you make of the case so far?
Two universes in this case. The universe where he did it and he's lying about it. The universe where he did it, but he's telling the truth about defending himself. We don't know which universe we live in, but either this guy is a arch charlatan who knows how to lie and emote properly and put on this facade, or he's not, or he's telling the truth, right? That's why the jury's going to have, they're going to have to ferret out this situation and figure out which one of these two universes we live in. But so far, him cooperating with the police, being compliant, calling the police, it bodes in his favor. Here's what I tell attorneys all the time, right? You obviously hold your breath any single time your client opens their mouth and talks to anybody, but you're lucky when you get a client who did speak to the police and does something that's in line with the defense you intend on putting together. That's why his defense attorneys will hold this on their sleeves and say, look at what he did. This is not the behavior of somebody who did something nefarious. So far, it's going to bode very well for him right now as the trial is underway.
Now, what we do know, Mike, is that there is surveillance video of what happened. It's kind of grainy, can't 100% tell what's going on, but what you can tell from that video is that he did embellish a little bit. What he tells them is that he attacked him, the guy attacked him, and that he was swinging at him. It's not clear whether he attacked him or not. You can get into that a little bit, but what is clear is that there was no swinging going on. How much will that end up hurting him? Again, this is directly after the incident. He's saying these things, maybe going on his head, a lot going on. What do you make of that aspect of it?
I use Greek mythology to describe these cases all the time, and now I'll say that the gods of the jury are always offended if you feel that you are offending their intelligence or lying to them. It never is good. There have been so many cases where a defendant, we know later on, was exonerated because other evidence came out, but was convicted because they said something that was a fib, was a lie, was an embellishment. This is a material germane fact in this case, whether or not he was swinging at him, right? Because if you're a juror at the end of this case and you're deliberating and you say, this guy's making up a story. He said things that ended up not being true. How can we believe that he was defending himself? And at the end of the day, he shot the guy who was unarmed. So it's going to be very bad for them. This aspect of it will be very bad for the defense.
Yeah, and again, the idea is, why would he try to embellish if he thought he was completely in the right? Right? He's trying to make it seem worse than it is, so it certainly doesn't bode well for him as far as that fact is concerned. Michael, stand by. I want to take a break now. Bring back in our guest with us to discuss, National Trial Attorney Michael Jaafar. Michael, this is a self-defense case. The defense has a couple of formidable hurdles to overcome. The first one is self-defense is justified when a person in Montana reasonably believes that the force used is necessary to protect themselves from imminent use of unlawful force. That's number one. Number two is the level of force needs to be proportionate, reasonably proportionate, to the amount of force that might be applied. Those are two formidable hurdles for the defense, don't you think?
Absolutely. And the defense has something to prove. I know technically the burden of proof is on the prosecution, but I always tell my clients and other attorneys, if you don't think you have anything to prove in a case, then why is there a case? You have something to prove. However, what benefits them is the fact that Montana law is kind of a stand your ground state. It's not technically that, it's called a no duty to retreat, but there are other states, like, for example, Connecticut, where you do have a duty to retreat. Montana, you do not have a duty to retreat, even if you could do so safely. This is a big deal, right? So in Montana, because of the fact that he had no duty to retreat, even though he could have easily, we don't know, there's no video of it, but let's just say he could have, they were using they were approached at a shared mailbox, so he was outside. He could have easily retreated. He could have ran away. If this case was in, for example, another state like Connecticut, we would be looking at completely different difficulty for the defense. But I do agree with you that they would have to show that he used proportionate force. This person who he had the attack with, it wasn't like we're talking about a gorilla versus a small little female. They were equally sized people, so it doesn't look like it was proportionate force, but at the same time, he did not have a duty to retreat. So that makes this case a kind of like a coin flip type of situation.
All right, now we do have a video of the event, Mike, and again, as I said, it doesn't quite show a swing being taken. It's not the clearest video. And the defense is trying to discredit the video, saying it's a very low value, right? So there are frames that could be missing. So things that you see, perhaps there's more to the video than what you actually see. One of the ways they're trying to do it, Mike, is, and you heard her talking about it on the cross-examination of that officer, talking about when he arrives on the scene, the victim is on his back. What we also know is that he has 2 gunshot wounds to his back. Now, if you're getting shot in the back, normally you will land forward. But her claim, and later on she talked about this in her opening statement, is the reason he was shot in his back and ended up on his back is because he was finished swinging, a swing that you don't see on the video. What do you make of that argument?
This is the bad side of the case for the defense, obviously, right? And she was very clumsily trying to get through it. There was an objection when she asked, "Hey, typically, wouldn't you fall on your back would you fall on your chest if you were shot in your back, etc.?" And then there was an objection. It was sustained. I thought that was weak. She could have come back and overcome that. But then again, she had a different way of attacking it, which is when you came there to do CPR, do you do CPR when they're on their back? And you said the officer said yes. Said, was he in a position for you to begin CPR right away? Yes, he was. And so this obviously a tension point for them. This is something very important for them because at the end of the day, they know that they have to contend with the fact that, he embellished about the swings, maybe just made up a lie, and whether or not he was shot in the back or in the front, which is the crux of the case. Because if the jury reasonably infers that he was shot in the back, I don't see how they acquit him of murder. I just don't see how they do it if they reasonably infer, if they conclude that he was shot in the back. If they conclude that the shots in the chest emanated from the front of his body, if they conclude that, then it's a much easier, thing for the defense to overcome, to kind of prove that there was reasonable doubt as to whether or not he was defending himself. But this is the case. The way you just framed it, this is the entire case.
Yeah, it really is. And I'll tell you what, it is an interesting fact that he gets, there are entry wounds on his back, but he ends up on his back. I think that's certainly an interesting fact. But here's something else that the defense has to contend with, Mike, and that he took 7 shots at this guy. He hits him with 3, but he took 7 shots at this guy. How does that play into this determination as to whether his actions were reasonable under the circumstances?
It leans against the defense on reasonableness. At least 7 shots, if you just count it, because in the jury room, the juries are going to count it out. They'll say 1, 2, 3, 4, 5, 6, 7, right? 7 shots. It's quick, but at the end of the day, 7 shots and somebody who was unarmed. I think all of this stuff bodes against them. Will they overcome? Will the prosecution overcome the burden with all of this because of Montana law? That's a tough one. That I don't know, but it bodes very poorly for the defendant. All of these things bode poorly for the defendant. Whenever somebody winds up dead in an interaction with a person who's, and they were unarmed into the interaction, the human being, the human psyche wants to convince itself that you did something wrong, because how many of us kill somebody who's unarmed? If we really think about it, obviously none of the members of the jury have been in that position. Maybe they know somebody or they've heard of somebody from high school who killed somebody. I went to high school with hundreds of people. I don't know of a single person who shot an unarmed person and killed an unarmed person. It's so difficult for you to grasp the fact that you are weighing innocence or guilt about a person. One last thing. My neighbor was an attorney. He was on a jury 2 months ago. Same situation. They convicted him.
All right, I got to get out of here, Mike. I'm coming up to a hard break. Thank you so much for joining me tonight. Always a pleasure to have you on the show.